Red Door Shield. Secure everything.
A small medical practice got breached, patient records exposed, names, birth dates, insurance information, diagnoses, the most private information a person has. And when I sat down with the owner, the first thing he said was, "But Tony, we are HIPAA compliant. We did the training. We have the binder. How did this happen?" That sentence right there is the most dangerous misunderstanding in healthcare today, because he believed that being HIPAA compliant meant being protected. Those are two completely different things, and the gap between them is exactly where his practice got hurt twice. If you run a medical, dental, or any kind of healthcare practice, I'm going to show you what HIPAA actually does, what it does not do, and the part it will not protect you from. Because the criminals attacking your practice do not care about your binder at all. My name is Tony Chan. I've founded Red Door Technologies, and in 17 years I have seen this exact misunderstanding cost good practices dearly. So here's the straight answer to the question: is HIPAA enough? No, it isn't. And here is why, in one sentence. HIPAA is a compliance framework. It is not a security system. HIPAA tells you what you are responsible for protecting and what happens if you fail. That is important, and you absolutely have to meet it. But a rule book does not stop an attack. A criminal does not hit a wall when they reach your HIPAA binder. Compliance is the floor. It is not the finish line. Let me show you why that distinction matters so much for a practice like yours. Reason 1. What you hold is dollar for dollar, some of the most valuable data on earth to a criminal. Think about a single patient record: date of birth, social security number, insurance details, medical history, diagnoses. It is a complete, permanent identity. Here is why that matters. A stolen credit card gets canceled in a day. A medical record cannot be canceled. The diagnosis, the history, the identifiers, those are permanent. That permanence is why medical records sell for far more than credit card numbers on the dark web. Criminals use them for insurance fraud, for prescription fraud, for identity theft that can go undetected for years. You are not holding ordinary business data. You are holding the single most valuable kind of record there is. That is what makes your practice a priority target, not an afterthought. Reason 2 is the part that catches owners completely off guard, and it is the real answer to what HIPAA will not protect you from. When a practice gets breached, you do not get hit once. You get hit twice. The first hit is the attack itself, the recovery, the downtime, the stolen data, the ransom. The same damage any business faces. But then comes the second hit, and this one is unique to healthcare: HIPAA itself, because a breach of patient data triggers your legal obligations. You must notify every affected patient. You must notify the government, the Office for Civil Rights, and that can open an investigation into whether your practice was actually protecting that data the way the rules require. So follow the irony here. HIPAA does not stop the criminal, but after the criminal is done, HIPAA can come back around and penalize you for the breach on top of everything else. You are the victim, and you can still be fined. That is the double bill, and it is the single most important thing for a practice owner to understand. Compliance on paper will not save you from it. Only real security will. And reason 3 is about where this is all heading, because the ground is shifting under your feet right now. For years, a lot of practices treated HIPAA as a checklist done once a year, a binder on a shelf, a training video. That era is ending. There is a major update to the HIPAA Security Rule that has been formally proposed at the federal level, and it spells out in black and white the kind of real security the old approach left vague. It would explicitly require multi-factor authentication, encryption of patient data, regular security testing, the exact protections that actually stop attacks, written directly into the rule. It is proposed, not yet final, but the direction is unmistakable. The standard is moving from do something reasonable to do these specific things. So if your practice has been getting by on a binder and a training video, understand that the definition of compliant is being raised to meet what security people have been urging all along. The practices that get ahead of it now are the ones that will not be scrambling later. So put it all together and picture what one breach actually costs a practice like yours. The most valuable data there is exposed data. Patient care disrupted while your systems are down. The notifications to every patient whose trust you held. A potential HIPAA investigation and penalties on top of the attack, and healthcare consistently carries the highest breach costs of any industry. But the deepest cost is not financial. Your patients gave you their most private information because they trusted you with their health. A breach breaks that trust at the most personal level there is. That is why medical practices are prime targets. The most valuable data, a double penalty when it is lost, a rising legal bar, and the most personal trust of all on the line. Here is the good news. Real security and real compliance are the same project. Do the protection right, and you satisfy the rules at the same time. One effort, both problems solved. That is exactly what our free business security assessment does for a healthcare practice. We look at whether patient data is genuinely protected, not just documented, whether multi-factor authentication and the other protections the new standard points to are actually in place, and whether, if the Office for Civil Rights ever came knocking after a breach, your practice could show it took real security seriously. You walk away knowing where you stand with criminals and with regulators. Before a breach forces the question, not after. No jargon, no pressure, just a straight answer from someone who understands what your practice is really holding. The link is in the description. And subscribe, because that wraps our industry series, CPAs, law firms, contractors, property managers, and healthcare. Next, I am shifting from the problems to the plan. I am going to start showing you exactly what complete protection actually looks like for a small business, in plain English. But if you run a practice, here is the takeaway. Being compliant is not the same as being protected, and the criminals are counting on you to confuse the two. The smartest move is to find out today whether your binder and your reality actually match.
Stop hoping. Start knowing.